Good morning. This is your Kelso Report for Friday, April 20th. I'm your host, Clark Kelso. We've got a full plate of cases to discuss, so let's get right to it. We begin with the Ninth Circuit in a habeas corpus decision involving limitation of actions. Now, under the Anti-Terrorism and Effective Death Penalty Act, there's a one-year period of limitation. The one-year period begins to run from the date on which the judgment becomes final in state court, either the conclusion of direct review or the expiration of the time for seeking such review. However, the time during which a properly filed application for state post-conviction relief is pending shall not be counted toward any period of the federal limitation. In other words, if a state post-conviction application is timely, the federal limitation period is tolled. Now, unfortunately, California does not have a clear set of timelines for post-conviction relief and appeals. Instead, the standard is whether the petition or appeal from denial of a petition was filed within a reasonable time. In Noble v. Adams, the district court examined a confusing sequence of state habeas filings and determined that the one-year limitation period had run. Well, the Ninth Circuit looked at the same set of filings and decided that the district court needed to make a further determination under California law whether a 4-month delay between the denial of his first petition in the Superior Court and his filing of a petition in the Court of Appeal was a reasonable time in the circumstances. Although an unexplained delay of longer than 60 to 90 days has been held unreasonable, the district court's going to need to examine the reasons for the additional 2 months of delay in this case to determine whether those reasons explain and excuse the extra time. Our next case is from the California Supreme Court involving a criminal procedure issue. The defendant in People v. Hernandez was convicted of attempted murder. He argued on appeal that the trial court violated his right to counsel as guaranteed by the Sixth Amendment by barring his attorney from discussing with him the existence or contents of a sealed transcript of a witness's plea agreement and a sealed declaration executed by the witness as part of his plea agreement proceedings. The Court of Appeal reversed the conviction, finding an absence of good cause for the order sealing the witness's declaration and concluding that barring defense counsel from discussing the declaration with his client violated the Sixth Amendment and required automatic reversal without a showing of prejudice. The California Supreme Court reversed. Now, while the United States Supreme Court has identified certain extreme denials of access to counsel at critical points during a trial as justifying reversal without a showing of prejudice, the situation in People v. Hernandez did not rise to that level of presumptive prejudice. Counsel was at all times present and at all times could confer with his client. The information in the sealed transcript was potentially useful for purposes of impeaching the witness, but counsel was not prohibited from making that impeachment. In these circumstances, according to the California Supreme Court, a reversal was warranted only if the defendant could demonstrate that the inability to consult with his lawyer about the contents of the sealed transcript affected the reliability of the trial process. The Supreme Court remanded to the Court of Appeal so it could conduct the analysis of prejudice in the first instance. Now we turn to the California Court of Appeal for a couple of remedies questions. In the first case, in what appears to be an issue of first impression in California, the Second District held that the prevailing party in an arbitration was entitled to continue earning prejudgment interest between the time the trial court initially vacated the arbitration award in their favor and the appellate court's reinstatement of the award in a prior appeal. The trial court had suspended the accrual of prejudgment interest after it vacated the arbitration award. Well, the Second District reversed, holding that prejudgment interest under Section 3287 of the Civil Code continued accruing during the pendency of the first appeal, and so it remanded for recalculation of the interest award. Our second remedies case involves punitive damages. In an asbestos case, the jury had awarded the plaintiffs compensatory damages of $1.845 million. In addition, the jury awarded punitive damages of $4.5 million. The defendant challenged only the amount of the punitive award, arguing that it was too high given the defendant's net worth, and that it was grossly excessive compared to the compensatory award and therefore unconstitutional. Now, frankly, in my judgment, this gets pretty close to being a frivolous appeal. The First District easily affirmed in Bankhead versus Arvin Meritor. On the net worth issue, the court pointed out the many authorities holding that net worth is only one way of assessing the defendant's wealth, and that an award does not need to be proportionate to the defendant's claimed net worth when there is other evidence of substantial wealth. In this case, for example, over the last 4 years, the defendant had $3 billion in sales and an annual cash flow profit of $110 million. And its CEO earned $7 million in 2010 alone, and stood to receive $20 million upon leaving the company. This was not a poor defendant. As for the constitutional claim, the ratio of punitive to compensatory was only 2.45 to 1, which is much lower than the 9 to 1, or even the 3 to 1 ratios referred to by the Supreme Court in its State Farm decision. Next, we have a consumer protection case under the unfair competition law. The plaintiff had filed a class action against a motorcycle dealership, asserting, among other things, that the dealership violated Business and Professions Code section 17200, California's unfair competition law, based upon alleged violations of Vehicle Code sections 11712.5 and 24014. Those Vehicle Code sections require that a dealer put a so-called hanger tag on motorcycles showing the manufacturer's suggested retail price and all dealer charges and markups, as well as some other useful information for consumers. The trial court entered judgment for the defendant on the ground that even though the hanger tag was missing, the consumer actually was shown all of the additional charges in the written contract of sale, and she therefore could not show reliance or injury from the dealer's violation of the Vehicle Code requirements, and had no standing to sue under the unfair competition law. The Second District reversed. To hold that the violation of the Vehicle Code requirements resulted in no injury and no standing, so long as the dealer showed the additional charges of the contract of sale, would have utterly defeated the legislature's intent in enacting the Vehicle Code requirements. After all, the whole point of the hanger tag requirement is to give the consumer pricing information before the consumer is enticed to sit down across the table from a salesperson. Well, the solution to the injury problem for the Second District was to conclude that the purchase price paid by the plaintiff included the dealer markups that should have been shown on the hanger tag, that those dealer markups were being unlawfully retained by the dealer, and that the plaintiff could recover those amounts pursuant to the restitutionary remedy provided in the unfair competition law. Next, we have a criminal procedure case on appeal in People v. Bajaza. The defendant argued the trial court erred in refusing to suppress evidence of statements made to the police after the defendant was handcuffed and placed in a police car prior to being advised of his Miranda rights. Among other statements that should have been suppressed, the defendant claims that his estimation of time made during a Romberg or modified attention test was in fact testimonial evidence and should have been excluded under Miranda. The Fourth District agreed that the trial court erred in admitting these statements, but it did affirm the conviction because it found the error harmless in light of substantial other evidence of guilt. Next, we turn to a family law decision. The trial court in In Re Alexis S. found that the father had inappropriately touched the half-sister of the father's 2 young sons. Based on that finding, the court had entered a dispositional order detaining the 2 young sons and limiting the father to monitored visitation with them. Well, the Second District reversed. concluding that evidence the father touched the half-sister inappropriately did not, by itself, support the conclusion that the two boys were at risk of sexual abuse. The trial court may not punish the father for his misconduct with one child by entering a dispositional order encompassing other children, absent evidence that they are actually at risk. Next criminal procedure case. During a traffic stop for failure to signal a left turn, a police officer discovered that the defendant was carrying a loaded handgun, despite his status as a convicted felon currently on probation. After the court denied the motion to suppress evidence under Penal Code Section 1538.5, the defendant pled no contest to a single count of firearm possession by a felon, admitted a prior conviction allegation under the Three Strikes Law, and was placed on felony probation. In People v. Durant, the First District affirmed the conviction, rejecting the defendant's claim that the court should have granted his motion to suppress. According to the appellate court, even if the traffic stop was unlawful, as claimed by the defendant, the pat-down search, which led to discovery of the handgun, was legal because of the usual probation search condition where the defendant had consented in advance to any and all warrantless searches. And that's it for today's Kelso Report. Have a great day in the law and a good weekend.